welcome to the 25th lecture of Hammurabi Tablet Forum. This is third season, first lecture, and also a Silver Jubilee program of Hammurabi Tablet Forum. And this is really a proud moment for us that because of continuous support from you all, we reached to this stage. Before start with our program, I like to introduce what is Hammurabi Tablet Forum and its purpose. Hammurabi Tablet Forum is a forum which runs exclusively for well-being of law students and budding advocates. Our intention is to give stage for young lawyers and advocates so they can perform there, they can present themselves confidently there, they build their personality. Initially, Hammurabi Tablet Forum starts with one segment where experts comes and delivers lectures to law students and advocates. But after continuous efforts of 2 years, we are conducting 3 different segments. One segment where experts comes and delivers a lecture. In a second segment, the lawyer who having 5 years and below practice who come as a guest and delivers a lecture. And recently we started another segment which is exclusively for students, where students come as a guest and delivers a lecture to students. So like that we arrange different activities, and I am requesting you all that support this cause, so we will conduct more lectures in future also. So I will give small introduction of our today's guest. Our today's guest is Advocate Anil Harish, who is a partner in Demergers and Company. He is also associated with one institution, that is Society of Indian Legal Firm, where he is Executive Vice President. He practices in international taxation, foreign investment, and he delivers lecture in FEMA law also. So I am requesting you all that take benefit of this lecture and implement in your today's practice. So let us welcome our today's guest, Advocate Anil Harish and Advocate Rahul Maskar. Let us welcome Advocate Anil Harish and Advocate Rahul Maskar. I would request Advocate Rahul Maskar sir to felicitate our today's guest.
Rajesh.
I would request sir to start with the program.
Mr. Rahul Maskar and friends, I am very pleased to be here at this meeting of the Hammurabi Tablet. It is said that a lawyer must work like a horse and live like a hermit. Well, a lawyer must work like a horse. There is so much to be done. All of you know that through the years of law college, and beyond that, the long hours are a part of every lawyer's life. But in this day and age, one just cannot live like a hermit. There are so many laws that are coming up all the time. There are so many changes in technology. There are developments in the manner of doing business and of living life, that there are new laws that are promulgated all the time. There are changes in the laws. There is case law that is coming up, and regulations and decisions of every kind, and factual situations. One has to be up to date at all times. You may go ahead on the basis of last week's decision, but then there could have been another one yesterday which just completely overturns it. So you just cannot afford to be behind the times at all. And it is not only being up to date, it is also having a depth of understanding and a breadth of understanding. You must know about many different laws because they are relevant in whatever you're doing nowadays especially. So I'm very pleased that the Hammurabi Tablet was started about 2 years ago, and that you have meetings like this in order to expose all of you. In fact, when I was Vice President of the Society of Indian Law Firms, that's the first thing that I did. I said that the Institute of Chartered Accountants of India, the Institute of Company Secretaries and of Cost and Works Accountants, and the Chambers of Commerce, the Indian Merchants Chamber and others, have so many programs to keep educating their members. But the Bar Council just doesn't do that. They have one set of lectures in the year which are not publicized at all. No one knows about them. I've attended, in all these 40 years that I've been in practice, I've attended only two of those lectures. One because my father-in-law was speaking at one, and the other because my brother-in-law was speaking. I have not even known about when those lectures were held. So I think that it's extremely important that you're doing this. I had series of lectures, 2 lectures on each Friday for 5 consecutive Fridays, and then another set of 10 lectures like that. And Justice Dhananjay Chandachud, Justice Shavak Vaziftar, Mr. Ravi Kadam, Mr. Janak Dwarkadas, Mr. Ram Jetmalani, and others had come. And there was so much interest in this because such a wide range of subjects was covered. So I'm very glad that you're doing this. This is an excellent initiative. Please continue it. And whatever I can do, of course, I will always be there to support, as will everyone else from our office, Ms. Divya Alexander, Mr. Ravi Rathi sir, and others. Our subject today is the scope of practice in FEMA. Foreign exchange regulation was introduced in India on 2nd September 1939, that is about 78 years ago, on the outbreak of the Second World War. The day the Second World War was announced, the British government said that there will be exchange control in India. Perhaps they did not want foreign currency to go out to support enemies of Britain, perhaps Japan or Germany, because at that time the British also in a sense were our enemies, they were our rulers, so they probably didn't want that. So exchange control was introduced on 2nd September 1939. And even though it has now been removed in the UK since many years, it continues in India. It's taken different forms in India. One, it began under the Defence of India regulations in 1939. Then in 1947, it was promulgated into a statute, the Foreign Exchange Regulation Act 1947. This was then substituted by another statute, the Foreign Exchange Regulation Act, FERA, again FERA, 1973, which took effect from 1st January 1974. There have been other significant changes since then, but the law used to be so extremely tight that it was said in the late 1940s and in the 50s that if a resident of India took a non-resident out for a meal, then he would be violating FERA. It was so strict. So what do you think today is the position? Do you think it's as strict now or not? No? Okay, we'll come to that. I'll show you what the position is. So in 1974, the second FERA was promulgated, and it was extremely controlling every transaction between residents and non-residents, or between non-residents and non-residents. Any remittance from India, any remittance into India was questioned in great detail. In 1977, when the Janata Party came into power and Mr. George Fernandes was minister, he cracked down on foreign companies. He said, we are not interested in having foreign companies here. They must Indianize if they want to continue over here. So he said that IBM, International Business Machines, which was the leader in technology, in information technology and computers in those days, he said IBM must Indianize. If they do not give a substantial percentage of a majority of their holding to Indians, to resident Indians, then they will have to close down. So IBM said, yes, we prefer to close down, and they actually closed and they left India. So you can see India was left so far behind in the technology field, in the computer field. It took us a long time to catch up, and it was only many, many years later with Infosys and Tata Consultancy Services and others that we came back into the field. But that really hurt India at that time in 1977. He did it for IBM, he did it also, for example, for Coca-Cola. And he said that Coca-Cola had to close down. So they did, because they didn't want to Indianize. Then we got Thumbs Up and other products. So there was some import substitution, some good came out of that at that time. But it was really a setback and things were very difficult. I'll give you some examples of what some of the cases that I did or that I worked on in the earlier years to show you what things were like and how difficult exchange control was. A client came to us and said that he had business outside India. He was advising people. He was a consultant and he used to keep going abroad regularly. So he said, it's very difficult for me to get in money into India from my clients, and then every time I want to travel to take money out from here and to spend any money to pay consultants and so on. So I need to have a company outside India. Now that was next to impossible to do because foreign exchange was so tightly controlled. So he said that he has a sister outside India. So I said, fine, let your sister form a company outside India. Let her give only 3% of the shares to you, only £3. It would be a £100 company and he would have £3 worth of shares. And I said, let her appoint you as a director. So under section 19 of FERA, he had to apply to the Reserve Bank to get permission to hold those shares. And under section 27 of FERA, he had to apply to the Ministry of Commerce in order to be a director of a company outside India, because both were essential. So we applied on the same day in a particular year, I think in January 1981. 1 year later, in January 1982, we got a letter from the Reserve Bank of India. We will consider your application to receive 3 shares as a gift only after Ministry of Commerce gives their approval for you to be a director outside India. And 2 days later, maybe because of the post, we got a letter from Delhi, from the Ministry of Commerce, saying we will consider your application to be a director of this company outside India once RBI gives you permission to hold 3 shares. So nothing happened for that much time. Then later the law began to change, and then he was able to get his permissions and so on. But it was extremely difficult. In 1982 was another important step, that on 14th April 1982, the Reserve Bank of India issued a circular in which they allowed non-residents to participate in activities in India, to make investments and so on. Before that, that had also been completely frozen. So in fact, one person came to me in the late 1980s or the early 1990s, and he said, I've come back from overseas and I went to my bank, but my bank account here has just been frozen. I do not know why. I've tried to operate it for the last 10, 15 years, but the bank just doesn't know why it's frozen. I don't know why it's frozen. I've never got any notice. So I said, I know why it's frozen. Because in the 1970s, when FERA 1973 had been promulgated, they had a tight control on everything. So if any non-resident had a bank account in India, it was treated as a blocked account. He couldn't even do anything with it. He couldn't withdraw any money. He couldn't use it for household expenses or anything. It was just a blocked account. So the moment he told me it's there, I had read all these things over the years. So I said, I know what it is. The account must have been blocked. The bank officials have changed from time to time. The present officials don't know that it was blocked because of FERA, but we'll write a letter. So I wrote a letter for him to the bank, and I said, I have this account since many years. I presume it was blocked under FERA under such and such circular and section, but now that the Reserve Bank of India permits NRO accounts, I want this account to be converted into an NRO account under such and such notification and circular and so on. Please do the same. So we wrote this one letter, then the bank understood why they had blocked it, and then they unblocked it and treated it as an NRO account. In 1982 or so, I wanted that our firm should open a branch in London because there were so many non-residents who wanted to invest here. So I made an application to the Reserve Bank. All that we asked for in terms of foreign exchange was 70,000 rupees, which was equivalent to about 4,000 pounds at that time. Only 70,000 rupees. Wrote a letter to the Reserve Bank. How long do you think it took for them to give me a reply? 4 years. 4 years they didn't give a reply. So I would go to the Reserve Bank and ask them, and they'd say, we've referred the matter to Delhi for a release of foreign exchange of 70,000 rupees. Finally, I went for some other matter to the Reserve Bank, and I told the person that your bank just messes up everything in India, and I don't feel like making any applications to you because this is how you've done it in our case. So then the officer says that now you write a letter to us saying that you're withdrawing that application for release of 70,000 rupees, but that you want to open an office outside India without any money, and then we'll give you the approval. So I did write such a letter. We got the approval, but obviously one could not do it that way. So then we dropped it and we didn't open an account outside India or an office outside India at all. So anyway, time went on. 1982, there was a liberalization when non-residents were able to invest. In 1991, when Mr. P.V. Narasimha Rao became the Prime Minister, Dr. Manmohan Singh became the Foreign Minister, the Finance Minister, then again things began to change at a corporate level. In 82, the changes had been at an NRI level, non-resident individual or Indian level. Now for companies were able to participate, invest in India, they were able to give technology and one could pay for technology, etc. That happened in 1991. Then in 1993, there was an ordinance and subsequently an Amendment Act to amend FERA in 1973. And then in 1993. And then in 1999, it was decided that FERA was very restrictive and very controlling and people were suffering a great deal and it was giving a very bad image of India outside India. So in Mr. Atal Bihari Vajpayee's time, FEMA was introduced. It was called FEMA 1999, but it took effect from 1st June 2000 in his tenure. Now FEMA was quite different from FEMA. It still regulated, but the penalties and punishments were much less severe. Under FERA, the penalty was a maximum of 5 times the amount involved in any transaction, and in FEMA it was 3 times. But in FERA there also used to be prosecution, and the reserve and the enforcement directorate officials used to be very rough. They used to beat up people all the time, they used to give them electric shocks and so on. FERA was very difficult to deal with. Now FERA was administered by 2 sets of officials. One was the Reserve Bank of India, which was, although very constrained, was very good to deal with, and the second was the Enforcement Directorate, which was very bad to deal with. That was the position. That continues to be the position today, that the Reserve Bank of India administers and the Enforcement Directorate enforces. But today the Enforcement Directorate has much less powers than it did under FERA, and therefore you don't hear about them so much and you're not so worried about them now. But there has been a change recently that I will tell you about as we go on. Now one provision which was relevant in FEMA was that there was a sunset clause, that the Enforcement Directorate could now take up matters and penalize only if they started the proceedings within 2 years from the coming into effect of FEMA. So that means for a FERA matter, there was no time limit. I remember people coming to us in say 1980 or 85 saying that we had done this in 1948 or 1950 and we are still worried about it because the proceedings can still be opened. But now finally when FEMA came into effect, then there was a finish to these old matters, and only if they were taken up by the 31st of May 2002 could those proceedings continue, but not otherwise. So then there was a time barring and many of those matters came to an end. I'll just point out one small thing. I'm telling you all these details because I think it'll help to give you a perspective of FERA and FEMA and therefore what the practice of this law will be like. Some years ago, one of the royal families of another country had come to consult me. Their person had come to consult me and they said they owned a property in India which they had not declared to the Reserve Bank even though they were foreigners. Now the Reserve Bank of India or the Enforcement Directorate could not penalize them because 2 years had already passed and the sunset clause had kicked in. But I said you must still make an application to the Reserve Bank of India. They cannot penalize you for contravening, but we must regularize it. So we wrote to the Reserve Bank of India and pointed out that this is a royal family and that they've had this property since 1956 or so, that they did not take approval under FERA, but we request you to kindly give us your approval for the record now, or to confirm that it's regularized and that we don't need your approval. Reserve Bank said, well, we will not penalize you, but we are not going to regularize it so easily either. So they refer the matter to the Ministry of External Affairs. And as they say, Delhi dur ast, that Delhi is very far away, whatever goes there doesn't easily come back. So the Ministry of External Affairs took about 2 years, and finally they wrote back saying yes, these are members of a royal family and that they've got diplomatic immunity and so on. Therefore, we are now giving our approval and they can continue to hold the property in Mumbai. So we were able to get that approval. Now, what then is exactly the scope of FEMA or FERA? What does it seek to regulate? Now it's called the Foreign Exchange Management Act. Earlier it was called the Foreign Exchange Regulation Act. It sought to regulate transnational holdings and activities. If a person is resident of India, as we are all resident of India, if we hold any assets in India, we have a bank account, we hold shares, we hold immovable property, we give a loan to someone, we take a loan from someone, we don't need RBI approval. We may be governed by different laws, by the Income Tax Act, by laws relating to ceilings on agricultural holdings, by the Companies Act if you're investing into a company, by the Partnership Act if you're in a partnership firm, etc. But FERA or FEMA doesn't come into the picture because we are residents doing business in India. So what is sought to be regulated? If a resident wants to have any holding or activity outside India, or a non-resident wants to have a holding or activity in India, or if a resident wants to transact with a non-resident in India, or a non-resident wants to transact with a resident outside India, or an Indian company wants to transact with an overseas company, then all these transactions, holdings and activities are regulated by FEMA, formerly by FERA, now by FEMA. So we come again to how strictly are these things regulated. You can go out with a friend who's a non-resident, take him out for dinner. Are you allowed to do that? Is it your innate right? Is it your right as a human being? Is it a right as a citizen of India to be able to take a friend out? Well, actually it's not allowed. It's only by virtue of a specific permission by the Reserve Bank of India that you are allowed to do so. So, let's slide on. Under para 2.1 of notification number FEMA 16 RB 2000 dated 3/5/2000, and you see it in the next slide, it says a person resident at the top, in pursuance of the provisions of section 3 of the Foreign Exchange Management Act, the Reserve Bank is pleased to permit to a person resident in India to make any payment in rupees towards meeting expenses on account of boarding, lodging and services rendered, etc. for a non-resident. So if this were not there and you were to take a friend out or a relative out, you'd be violating the law. So it's still so strictly controlled, but because the Reserve Bank of India has liberalized it over a period of time, that's why we are okay. But till the year 2000, you were not okay, till that was issued in June 2000. Now FEMA applies to individuals and to companies. So let's take an example of what happens all the time. Many of us have friends and relatives who've gone abroad, and they go abroad, they study outside India, or they work outside India. They may go for a few years, or they may go abroad indefinitely. Some of them will come back, some of them will not come back. What is their status, and does this law apply to them? Does it affect them in any way? Are they obliged to make any declarations? If so, to whom? What is the definition of non-resident? Is it the same under all the laws? Is there one standard definition of non-resident, or are there different definitions? Let's consider individuals first, then we'll come to companies. Under the Income Tax Act, Section 6, there is the definition of resident of India and non-resident of India. Under Section 6, the definition is based primarily on the stay in India or outside India. If you spend so many days in India, you're resident. If you spend so many days outside India, you're non-resident. But it's not as simple as that. There are many complexities. But essentially, the definition under the Income Tax Act, under Section 6, is based on the number of days that you spend in the country or outside the country in a financial year. The Income Tax Act looks at the financial year 1st April to 31st March as the period for determining whether a person is resident or non-resident. The definition under FEMA is different. This is under section 2V and section 2W. Now, we use the term non-resident or NRI very frequently, and that was the term that was really popularized by the Reserve Bank of India. But actually the FEMA itself and FERA before that did not use the term non-resident Indian. The Act did not say NRI or non-resident Indian. The Act said resident in India or resident outside India, not non-resident. Non-resident is the term used under the Income Tax Act and used under the circulars of the Reserve Bank of India. But 2V, section 2V defines resident in India, and section 2W defines resident outside India. Now, you will find that these definitions are quite different from each other. In fact, I remember once I happened to meet Mr. Ashok Sen, who was one of the greatest lawyers of India and who was Law Minister of India twice. And even in that lunch meeting, we were sitting together, he said that it's so strange, as Law Minister he said, it's so strange that the definition of non-resident under the Income Tax Act is different from the definition under FERA. But he was Law Minister and he didn't change it. So there are differences. And because the definition is different, then the impact of that will be different. So you can find that a particular person is resident under the Income Tax Act and happens to be non-resident under the FEMA, or vice versa. Of course, all of us are resident of India under the Income Tax Act and under FEMA, and there will be some people who are non-resident under the Income Tax Act and under FEMA, but a mismatch is also possible. So we must always be ready for that a person will tell you, I'm non-resident. Well, you can get into a discussion with him. Are you non-resident under the Income Tax Act? Are you non-resident under FEMA? And those are interesting intellectual discussions, but we need to know it insofar as our clients are concerned, to be able to advise them properly and to ensure that they stay on the right side of the law. In the same way, the term person of Indian origin, I'll come back to the definition of non-resident, but the term person of Indian origin has been defined in so many different ways. If you look at the Foreign Exchange Management Deposits Regulations, it says a person of Indian origin means a citizen of any country other than Bangladesh or Pakistan if he at any time held an Indian passport, etc. Now you go to the next one, which is the Acquisition and Transfer of Immovable Property Regulations. Here it says a PIO means an individual not being a citizen of Pakistan or Bangladesh or Sri Lanka or Afghanistan or China or Iran or Nepal or Bhutan. Then we go to the remittance of assets. Now here again it's Bangladesh or Pakistan. Then when we go to the next one, investment in firm or proprietary concern, it talks of Bangladesh or Pakistan or Sri Lanka. Then if you go to the explanation to section 115C of the Income Tax Act, it says a person shall be deemed to be of Indian origin if he or either of his parents or any of his parents or any of his grandparents was born in undivided India. So no reference to any of those other countries. So you can see all of these are there. And then you go to the PIO card, which is no longer there now because now there's the OCI card. And the PIO card has a completely different definition from all of these others. So you can see in law as in life, don't take anything for granted. If a person tells you he's non-resident, well, he may be non-resident under the Income Tax Act, but he may not be under FEMA. If he tells you he's a PIO, he may be under one set of regulations, may not be under another set of regulations. And therefore, he should not feel, I'm a PIO, I've got a PIO card, therefore I can buy property in India, I can do this, I can give a loan to someone, I can make a deposit, I can buy shares. No, it may not be so. And there are sometimes very unusual situations. A person came to me who was born in 1946 and he happened to be in Bengal, he was Bengali. But in 1947, India was partitioned. So the place in which he was living happened to go into East Pakistan. And then in 1971, that became Bangladesh. And he didn't have a passport all this time. He was only 15 years old. but he was born an Indian citizen. He didn't have a passport, but he was born an Indian citizen. Then he became a Pakistani. Then he became a Bangladeshi. Then he went to England and he got a UK passport and he got married to an Indian lady. So he wanted to buy a house in India. So he came to us. So I went through everything and I said, I feel that you are a person of Indian origin for the purposes of section 31 of FERA. That was the position at that time, before this. So I said, you are a person of Indian origin and you qualify and you can get the approval. So let's write to the Reserve Bank. So we wrote to the RBI. RBI rejected. They said, no, he's been a Pakistani and a Bangladeshi, and so therefore he's not allowed. I said, no, that's not correct. You must look at the law. What is the law? And what are your regulations? Your regulations say that a person, if he was born in undivided India, qualifies to hold immovable property. He is to be treated as an NRI. It doesn't say, or non-resident of Indian origin. It doesn't say, it doesn't exclude. At that time, it did not exclude persons who had been Bangladeshis or Pakistanis. So I said, you have to give the approval. Correspondence went on for 6 or 8 months, but finally we got the approval for him. But now that's not permitted, because now the OCI regulations have just come, which have changed all that. And if they say that even though a person may have been of Indian origin, if he has been a Pakistani at any time or a Bangladeshi at any time, then he is not qualified under the automatic regulations. Then he would have to apply to the Reserve Bank of India, and RBI can give him specific approval or deny him approval. So you have to go into all of these in great detail and see what exactly fits you, because it's not one size fits all. Now let's just go back a little bit and I'll tell you something more about non-resident status and how it is defined under the Income Tax Act and under FEMA, and what are the steps when a person wants to become non-resident. If you see, under the tax laws, section 6 has 3 different conditions. One is that this is a status that is determined from year to year, financial year to financial year. It is by and large, not 100%, but by and large objectively determined. And the criterion is the number of days in that particular year. So if you find that you've complied with those conditions, then you may be non-resident in that year, and that's it. That's objective. You show your passport to anyone and they'll verify that you're non-resident. But FEMA is subjective. Section 2V and Section 2W, earlier 2P and 2Q under FERA, are subjective. The criteria are intention, stay and activity. Let me give you an example. Some years ago, many years ago, when there was a problem in Iran, a person had come to us. He was an Indian citizen. He had been living in Iran, and he had his business there, his shops and all that. There was a problem there, so he bought a return ticket. He came here. He thought, I'll go back in 1 week or something like that. But the problems continued. His employees were running the shop, and he trusted them, and he knew that they would do it well. So he remained here, not 1 week, but 1 month, 3 months, 6 months, 8 months. Now his status under the Income Tax Act had changed, because he was spending so much time in India, and that's a status that is dependent on number of days. But had his status under FERA changed? Well, I told him, I feel that your status has not changed under FERA, and that you are entitled to continue to retain your business and your holdings and your activities and your bank accounts outside India. You don't have to close everything up and bring it back into India, which was the law at that time. Now they're much more liberal. I said, you can continue to hold of these, because I feel that you're still non-resident on account of the subjective nature of the definition at that time of 2P and 2Q, now 2V and 2W. So I wrote to the Reserve Bank of India, and I must tell you that my experience with the Reserve Bank was and continues to be very good. The Reserve Bank of India understood the situation. They said, even though he is spending a lot of time outside India, because this is what I had written, and I had said that he has an intention to go back, he's got a return ticket, here's a copy of his return ticket. He has no business here, there's a copy of his income tax return in India, he has some little bank interest, but he's not doing anything, and he's just getting letters from his staff over there telling him this is the activity, these are the sales on every day and so on. So therefore, his desire is to be back over there. His desire is not to be here. His income is there, his activity is there. It's just that his return ticket is over here. So the Reserve Bank said, yes, we confirm that he is non-resident. He does not need to close up his activity. He doesn't need to bring everything back into India. So there was a mismatch in that situation, and that quite often happens. Suppose a person goes outside India and falls ill on the 1st of April and stays outside India for 365 days. He doesn't want to be in the hospital. He wants to come back to India. He's being funded by his family in India. They are sending the money for the hospital. But he'll become non-resident under the Income Tax Act. He'll still be resident under FEMA. So there can be these mismatches, and you have to go into this in great detail. Now we move on to what is the structure of FEMA. So we've talked enough about FERA and these distinctions. Let's see how does FEMA actually work. FEMA is quite a brief statute, only 49 sections. Up to section 9 relate to the substantive aspects, and sections 10 onwards are the procedural and the administrative and enforcement aspects. So there's the Act, and then there are the rules. There are several sets of rules. There are many regulations. The regulations are the one which actually lay down what a person can do and cannot do. Then the Reserve Bank of India supplements these by notifications and by circulars, and now by what are called master directions. So the Reserve Bank of India, as I've said, was very good, and they were amongst the first government authorities, perhaps the only ones, to want to make it easy for people. So the Reserve Bank of India itself had what they called an exchange control manual. They used to keep coming out with circulars, and from time to time they would write out everything. The Act was there, but then all the regulations they would put into the form of an exchange control manual. Now the Reserve Bank of India doesn't do that, but private parties are doing that, including one retired officer of the Reserve Bank, Mr. D.T. Khilnani. He's the one who's written several books on FEMA. And what the Reserve Bank does now is something even better. They come out periodically with circulars and notifications, and then they will encapsulate all of these into a master direction or a master circular. So they'll have a master circular, for example, dated 1st July 2018. Now once they've put everything into a master circular, then you know that you don't have to look to whatever happened before that. You don't have to go into history and see is there anything contrary to that. Whatever was contrary is now overruled because the master direction is there. You have to look beyond the master direction. Suppose the master direction was issued on the 1st of July 2018, then it doesn't mean that you stop looking at all. Then you must see, did anything happen from the 2nd of July 2018 up to today? If there is something, then you will treat the master direction as the basis and the circular, the new circular, as modifying that master direction, so that you look at that and anything later. And the next year they'll come out with a new master direction which will take into account all the circulars that were issued in the meantime. So the Reserve Bank of India is very good with this. They come out with very clear master directions. Sometimes there is a little bit of a gap. Sometimes it's different from what the law is. Sometimes it's not very clear. Sometimes they come out with FAQs to explain the master directions, but the FAQs give a different answer. So we've had occasion to write to the RBI and say that your master direction says this, or your notification says this, but your FAQ says something else. Which of the two is correct? And the Reserve Bank of India is good enough when they find an error to quite often correct it or to give a positive reply, which is unlike what most other government departments do. I remember one of the first speeches that I gave, I think the first one was on FERA. And I said that the Reserve Bank is so good and the Income Tax Department is so difficult. And one person got up, he said, I'm an income tax officer. So he was very upset with that. But this is the way the Reserve Bank goes about regulating. They also issue press notes. Then you must look at the forms. There are detailed forms for many of the things. And then there are the FDI regulations. So all of these together constitute the law, and of course decisions of the courts. Now, there are several different rules: the Appellate Tribunal for Foreign Exchange rules, adjudication proceedings rules, authentication of documents rules, then compounding proceedings rules. This is an important thing. I'll come back to that later. And encashment of draft rules and so on. Now, there are many regulations. These are the substantive portion of FEMA, the Foreign Exchange Management, Acquisition and Transfer of Immovable Property in India regulations, and immovable property outside India, and so on. All these regulations are there. From time to time, the Reserve Bank of India modifies these. When they modify them, then they put an R after that. They'll say Foreign Exchange Management, Acquisition and Transfer of Immovable Property in India, into bracket R regulation. That shows that those have been rectified or amended. So if you see that, then you know that it prevails over the earlier one. So Reserve Bank makes it very clear in these things. Now, the substantive portion again of FEMA is this, that section 3 says that no person shall, save as provided, deal in or transfer foreign exchange or foreign security. I talked to you about that they control every kind of foreign transaction between residents and non-residents and in relation to currencies. Make payments to or for the credit of any non-resident, receive money from a non-resident, or enter into any financial transactions. Then there are restrictions on holding, ownership, possession or transfer of foreign exchange or foreign security or immovable property. The Reserve Bank also makes a distinction between current account transactions and capital account transactions. By and large, they permit current account transactions, and capital account transactions are much more restricted. So current account transactions will be payments for travel, payments for import of goods and so on. Capital account transactions will be when you want to take a loan from overseas, or you want an investment from overseas, or an investment from here to overseas. A kind of layman's distinction between current account transactions and capital account transactions will be that a current account transaction will be one which would be reflected in the P&L account, in a profit and loss account, and a capital account transaction which will be one which is reflected in the balance sheet. So if you buy goods, then that's a current account transaction because it will go towards cost of goods, and then later you will sell those. So that's a P&L account item. If you take an investment from anyone, that affects your balance sheet. If you take a loan, again, that's a liability in your balance sheet. If you give a loan, that's an asset in your balance sheet. So that's by and large the distinction between a current account transaction and a capital account transaction. Now, the Reserve Bank of India is very concerned that if a person exports goods, then they must bring in the foreign exchange. Sometimes people don't do that. People just send out the goods, keep the money outside, and don't bring it back to India. India's foreign exchange position is much better than it used to be when, for instance, Dr. Manmohan Singh became the finance minister. That time, as you know perhaps, he had to take gold from India and go out and pledge it in order to raise foreign exchange. Our position is much better now, but nevertheless the Reserve Bank of India is very concerned about getting in foreign exchange for export of goods. If a person doesn't do that, if he doesn't bring in the foreign exchange, then the matter may be referred by the Reserve Bank, by the bank to the Reserve Bank, and by the Reserve Bank to the Enforcement Directorate, and the Enforcement Directorate then can penalize the person. But now the RBI regulations are more liberal than they used to be. Earlier you could not write off any amount. Suppose you had exported to a person and he was not able to pay. The person went bankrupt outside India. That can happen. You had to write to the Reserve Bank and get their permission. If they were not satisfied, they would refer the matter to the ED. But today they have come out with detailed regulations and notifications and circulars whereby they say that up to 5% of your foreign exchange earnings you can write off. So they give you that much liberty, and in some cases even up to 10%, provided you give up all other benefits that you may have got in terms of licensing and so on. Now let's come to section 13. As I mentioned earlier, the penalty under FERA was up to 5 times the amount involved, and there could be a prosecution as well, which is what gave the Enforcement Directorate such powers, and people were really frightened of them. When FEMA was introduced, it was a conscious decision to make it a much more business-like statute, and that the penalty was 3 times, which was very high. But they did have a set of compounding proceedings, which I referred to earlier. But there was no prosecution. Now, in Mr. Atal Bihari Vajpayee's time, there was no prosecution. Now, in Mr. Narendra Modi's time, there has been amendment to this section, Section 13, and subsection 1B has been introduced by the Finance Act 2015, which says that there can be an imprisonment up to 5 years and a fine, and in addition to the penalty, a direction may be issued to confiscate the foreign currency or security, and also there can be a direction to bring it back to India. So you can see there's not only double jeopardy, there's triple jeopardy here. There can be a 3-time penalty, there can be a prosecution, and your asset can be confiscated. So this is very serious. Now this has come about from 2015. What has only helped the people of India is that the Enforcement Directorate is not as efficient as one would want generally government authorities to be, or anyone to be. But because the Enforcement Directorate is not so efficient, that's why they've not really done these things. When they become efficient, you'll find that there'll be many more prosecutions, there'll be much more brutality, there'll be much more roughness when they realize that they've got these powers and matters come up before them. Today they're only going on the basis of that penalty, and you go to them for a hearing. Divya goes very frequently, Ravi goes, and they just hear the matter, then after 6 months will be the next hearing. They don't really go into it in detail. You have to force them to actually concentrate and do it, and Divya has been able to do that very well, but some matters just go on and on. But when they realize their powers, when they feel those powers again, it's going to be much more difficult for all of us, because even the most normal things will then be subject to questioning by the Enforcement Directorate. Now, what are the things that an individual can do in terms of FEMA? A non-resident can remit money to India for expenses here. He can remit money to do business in India. He can remit money to buy shares either of a private limited company or even on the stock exchange if he's a person of Indian origin. What can a person who is resident of India do? And a non-resident, if he's got money in India, can remit out up to $1 million per financial year. So suppose there's a person who's non-resident, and let's say his parents passed away and he's inherited a property here or inherited money in India. Or let's say he had money here before he left. Now he doesn't need that money, he's not coming back to India, he wants to take it out. Now he's permitted to take out up to $1 million per financial year from out of his own funds. In the 1960s, if you wanted to travel outside India for a holiday, do you know how much you were allowed to take? How much are you allowed now to take? Do you know? If you want to travel abroad, you can take out up to $10,000 easily, up to $25,000, and even up to $250,000 per financial year if you want to go abroad now. But in the 1960s, if you wanted to go abroad to travel for a holiday, for example, you were allowed to take $8. That's all. And a dollar in those days was not 70 rupees, it was 4 rupees 75 paisa. So you were allowed to take out less than 40 rupees in order to go out for a holiday. So you had to have someone at the airport to fetch you there, and if the plane was late, you didn't have enough money even to take a taxi to wherever you're going. One person actually told me this. He said, Mr. Mansakan, Kishu Mansakan, he said that when he was a student, he's now about 80 plus, so when he was a student and he went to America, his plane was late. When he took a taxi from there and he went to his relative's house. But they had expected him earlier, and since he had come late, they were not at home, they had gone for their work or whatever. So there was no one at home. He rang the bell and it was snowing, it was so cold over there. There was no one opening the door. The taxi driver thought that this person had come to cheat me. So the taxi driver started beating him up over there because he had only less than $5 with himself. He had spent something on the way. So he had $3 or $4 and he was just sitting out for hours after the taxi driver beat him up, sitting outside the house till his relatives came home and took him inside. That was the position India was in. So now things have changed a lot. Up to $1 million can be taken out by a non-resident every financial year. What can we as residents of India do? We can take out up to 250,000 US per financial year, and now you do not even need the approval of the Reserve Bank of India to, having taken out this money up to 250, to open a bank account outside India. You don't need prior approval, it's part of the general regulations. You can invest in shares of a company outside India. You can buy an immovable property. You can make a gift of this money to anyone. You can give a loan to anyone. You can't take a loan because a resident Indian cannot contract foreign currency debt, but you can give a loan. So you can spend it in practically every way, but you can't spend it in every way. There are still things that you can't do. You can't, for instance, buy a Playboy magazine. It says that's not permitted. You cannot gamble. So one person came to me 4 or 5 years ago, and he said he had gone for a holiday to Dubai, and at Dubai airport on the way back he saw these very attractive signs there that buy a ticket for $100 and you can win a prize of so much. So he just bought a ticket. He came back to India, and a day or two later he found that he had got a prize, a lottery prize of about $1.5 crore. So he was very happy, and he went straight to his bank and he told them that I've got this money and it's going to be coming now. So when it comes, please just inform me, and of course credit it to my account. So the bank said, yes, congratulations, and so on. 2 days later, he got a call from the bank, but then after half an hour he got another call from the bank saying, yes, we just informed you that your money's come, but we have to inform you that we can't credit it to your account because we've just realized that this is a gambling win and we are not allowed to credit your account, so we are going to write to the Reserve Bank of India. So they wrote to the Reserve Bank, and the Reserve Bank froze the amount. They told the bank, you cannot credit it to his account. So the poor man came to me and he said, what do I do? So I said, now you have to go under the compounding regulations. This is a contravention, but the Reserve Bank of India treats contraventions in different ways. Some of them are havalas, actual illegalities, where you buy foreign exchange with number 2 money, or you get it outside, or you have foreign exchange and you convert it through an illegal manner. And then there are other things where everything's officially done in a different sense. It's official, it's through banking channels, but you violated some regulation. So I said, let's apply to the Reserve Bank of India for compounding. Now you can't just compound it voluntarily, suo motu. The Reserve Bank has to tell you that you may compound, but you can write to the Reserve Bank and say, I've done something wrong, please ask me to compound, and I'll compound. So anyway, we made a compounding application. You have to give a fee of 5,000 rupees, fill up an application form, and they give you a hearing, and then they decide. So I wrote to the RBI on his behalf. I said, this man went, he's earned foreign exchange for the country, and he's contributing to the exchequer because under the Income Tax Act, only 5,000 rupees is exempt. The balance is subject to tax at the maximum marginal rate. So on this $1.5 crore or so, you'll have to pay about 50 lakhs income tax. So what he's done is good for the country. So please compound. So the Reserve Bank of India had a hearing. They did levy a compounding fee about 4 or 5 lakhs of rupees, but he didn't mind that because at least it was done and he was able to get the rest of his money into his account. So the Reserve Bank of India has been good with these things. And this is the way in which one might use a compounding. Now, another interesting matter came up in which Ravi has been appearing before the Enforcement Directorate. There was a person who was Indian who invested in a company, and a foreigner, an Englishman, also they had become friendly outside India, and the foreigner invested here. There were disputes and differences between them after both of them invested. Then the foreigner filed a suit against this one in the High Court. And he found that the Indian person had not filed the appropriate forms, the appropriate declarations to the Reserve Bank of India on time. So that person also complained to the Enforcement Directorate. Therefore, the Enforcement Directorate took up the matter. Actually, if you file the forms late, that's like an irregularity. That's not really an illegality, because the money had come in through banking channels. It's just that you've not informed the Reserve Bank, got given an inward remittance certificate, you've not given the form FCGPR, etc. on time. So, since we had not done that, but the Enforcement Directorate had taken up the matter, we applied to the Reserve Bank for compounding. They said, well, now the matter has gone to the Enforcement Directorate. So now we are appearing before the ED. If that person had not complained, RBI would have decided in the compounding. But because it's gone to ED, to take it out is very difficult. So now we'll have to handle it over there and explain it and point out that this is truly a compounding matter. It's not a penalty matter under the ED, but please just go ahead and regularize it or levy some small penalty or a token penalty, which they have the right to do, because they can levy a penalty of up to 3 times, doesn't have to be 3 times. So we are trying to play on the sympathetic day, and we say now the parties have settled their dispute, the matter is withdrawn from the High Court, they have no dispute against each other, so please don't have a dispute with us. So that's the way the matter is going, and hopefully it should be resolved soon. Now NRIs, as I said, can also invest in on the stock exchange. What can foreign companies do? In the old days, in the 1970s, for instance, it was very difficult for them. But now we have the FDI policy, the Foreign Direct Investment Policy. That means an individual or a company outside India can invest into an Indian company and be issued shares. However, the FDI policy consists of different categories, categorizes different kinds of activity in different ways. Some things are completely permitted under the automatic approval route. Some of them are under the automatic route but with certain conditions. And some need prior approval, and some are prohibited. So you have different kinds of activities. The FDI policy is detailed and it is updated regularly. The last time it was updated was in 2017, but there's been another circular about a month or so ago. So you have to look at the 2017 policy and the updations in order to know what you can do. Some of the issues that come up are, what about defense? Can a foreign company participate in manufacturing for defense? Can a foreign company participate in retail? You know, the retail issue is quite often written about in the newspapers. Can Walmart open here or can it not open here? Will it take away the jobs of people in India? Are some things to be preserved for the small and medium sector enterprises? Can a foreign company do real estate business in India? What does real estate business mean? Does it mean constructing? Does it mean leasing? Does it mean buying and selling of immovable property in TDR? Does it mean agricultural activity? All of these are the subject matter of very detailed regulations by the RBI, which run into thousands of pages. So you have to go into each thing. Whenever the question arises, don't just look superficially. You must go into it in detail and understand everything that applies and see what are the procedures and the forms as well to whom you need to apply. Now, I've talked about borrowing for a reason, and that is that Indian companies often used to try and borrow from overseas, and Indians also, because in India at one time the income tax rates used to be very high. Do you know what the maximum rate in India used to be for individuals in the 1970s? Can anyone? Do you know what the maximum rate now is? About 35, 36. And what was it in the 70s? 97.75. And that was the rate applicable to your income as assessed by the income tax officer after making the disallowances in the Income Tax Act. So a person could have an income of ₹1,00,000, an actual income, but because of the disallowances, it would be treated as 1,10,000, and he'd have to pay 97.75% of that. So capital generation just was not possible. There also used to be wealth tax, which was very heavy. There was estate duty. Do you know what the estate duty rate was? Above 20 lakhs of rupees, it was 85%. So if you had wealth of 20 lakhs, on that first 20 lakhs it was about 6,72,000, and above 20 lakhs it was 85%. That's why all the Maharajas really got finished in those days. They had huge estates, they had to pay wealth tax every year, they couldn't pay it. If they sold an asset, they first had to pay the capital gains tax, then they would pay the wealth tax. They also had to eat, but that was not considered important. And then if a person died, then his family had to pay estate duty. So it was very difficult for them. So no capital generation was being done, which is what led to the black market in India, which led to violations of the Income Tax Act and FEMA and so on. So in any case, people in India used to want to borrow from outside because capital generation was just not possible here. Now borrowing can be either in rupees or it can be in foreign exchange. A foreigner may say, well, your Indian rupee is falling at the rate of 6 to 8% every year on an average. We don't want to be repaid in rupees, it will have no value. It's not as bad as Venezuela, but it's still quite bad. So we want a dollar denominated loan. If I'm giving you $1 million, you have to pay me interest in dollar form, and you have to give back that money to me in dollar form. The exchange losses to your account. So that is called external commercial borrowing, ECB. Or an Indian company can float bonds which are foreign currency denominated, which are FCCB, foreign currency convertible bonds. So you can have loans in rupees and loans in foreign currency. Now all this is also highly regulated. For what activity you can take a loan, to what extent you can take it, for what purposes you can take it, what is your rate of interest, how quickly can you pay it back, how slowly can you pay it back, everything is regulated. So if you take a loan and you want to pay it back within 3 years, you're not allowed to do so. You have to have a minimum maturity of 3 years. So you've got the money, you made a huge profit with that, you want to pay it back, but you can't pay. So the ECB regulations also are very detailed and very tight, and you have to look into all of those if ever any such situation comes up. Now another thing that has happened recently is the ODI in the last few years. FDI is when foreign direct investment comes in, when money comes in. What if we want to invest outside India? Yes, under the LRS, the Liberalized Remittance Scheme, we are allowed to remit out up to $250,000, as I told you. But there's another facility also, and that is the ODI, Overseas Direct Investment. So an Indian individual who is carrying on business, or an Indian partnership firm or an LLP or a company is allowed to remit money out under the ODI scheme. And now this is not to be handled by the Reserve Bank of India. This is a power that is delegated to the banks. So you can fill up form ODI and go to the bank, and if you have money in your account, you tell them, this is what I want to remit out. I comply with all the regulations. This is the amount that I want to send out, and they will allow you to do it. Briefly, the regulation is this. For example, if there's a company, if the company has net worth, that means capital plus reserves of, let's say, 1 crore, then the company is allowed to remit out under the ODI scheme 4 times the net worth. So that means 4 crores. So it has its own 1 crore. It can even borrow 3 crores and remit out this 4 crores of rupees for investment into another entity outside India, or for a loan to that entity outside India. You also have to be mindful of the tax regulations, that if you give a loan to an entity outside India, it might be treated as under the Companies Act as a related party transaction. Under the Income Tax Act also it can be subject to the general anti-avoidance regulations, GAR and so on, and also under the transfer pricing regulations, because it's an associated enterprise. So it's not only FEMA that you have to be concerned with, but also with other related laws. However, all these things are regulated. Now, a foreign company can set up a subsidiary in India, or can make an investment into India, or can set up a branch office in India, or have a liaison office. A branch office is one which can do operations. A liaison office is one which is not allowed to earn even 1 rupee in India. It can only spend money. So, for instance, there was a big garment manufacturer, a big garment retailer outside India, and they used to source from India. So they used to buy from different suppliers in India. Now they needed to carry out inspection, and they needed to know who are good suppliers. So we applied on their behalf for a liaison office to be set up in India. They opened the liaison office, they had a bank account, they would remit money into that account, and that money would be utilized here for the expenses of their staff, to check the garments and so on. After some years they decided to close it. So they still had some computers, they had a car, a Xerox machine and so on. So they said, okay, we'll sell off these things, we'll get about 2-3 lakhs of rupees. So we wrote to the RBI. RBI said, sorry, you're not allowed to earn even 1 rupee in India. So whatever you want to do with that, you do, but you can't get any money. So what they did was that they gave it to their employees and told them, this is your bonus now. So you can sell it off, you earn whatever you want to with it. We are not allowed to deposit any money back into our account. Whatever came in, if there's some surplus left, that we are allowed to take out. But we cannot deposit any fresh rupees into our account. So that process of closure of the liaison office also took us about 6 months, but then finally it was done. Now, we come to the administration of FEMA. I've talked about the regulations and the compounding, and then the enforcement directorate, which levies the penalties, and then of course which will initiate the prosecutions in future. So what is the scope of practice under FEMA? One is advisory, that if anyone is doing a transaction with a non-resident, or a person is a non-resident and wants to make an investment in India, then you can tell them the regulations, whether they want to invest in a firm or a proprietary concern or an LLP or a private limited company or a listed company, or they want to buy property or sell property, etc. You can advise them on that. Then even if they do something which is permitted, they have to submit the appropriate forms. If they don't, then the matter will go for compounding, there'll be high fines. The Reserve Bank of India used to be very flexible on the fines or compounding fees, but now they've come out with a very detailed circular wherein they've specified how much will be the compounding fees for every kind of contravention. And those are still quite reasonable, but when the figures are large, it can be also quite high. So you have to look at all those, and therefore you have to ensure that a person complies with everything properly so that the compounding fees are not levied. And the difficulty is that if you contravene and you go for compounding once, you can't next month make another mistake and say, now I want to go back for compounding a second time and a third time and a fourth time. It's not that you have a drink and take a and then get over your hangover and then take another one and have another hangover. No, you do it once, then you have to have a break, then you can do another contravention. Then, so you can make applications to the RBI for compounding if there's been a contravention. There are some grey areas, as I said. In fact, Ravi had pointed out one to me some time ago, that under the LRS, the Liberalized Remittance Scheme, they said you can invest in shares of a company. But they didn't say you can incorporate the company. Actually, investment in shares as a term is wide enough to include being the initial subscriber. But in certain FAQs, the Reserve Bank said you can use your LRS money to invest in a company. That does not mean that you can start the company. Although the term investment should be wide enough to include the initial investment and subsequent investments. But the Reserve Bank of India took that seriously, and therefore up to 2013, if a person had used his LRS money and started a company, then they have referred the matter to the Enforcement Directorate in some cases and said that you will be penalized. Now they've clarified that, but in the old days what you could do was you'd have to ask a friend to form the company and then buy his shares over from him. Or let him start the company and you put in the further amount. He can put in $1, you can put in $100,000, but you can't put in that $1 yourself. So you have to be careful about FEMA also, like every other law, but this is very highly regulated. So sometimes gray areas come up. Like for instance, another thing, we often hear of the term round tripping. Have you heard the term? Round tripping. Round tripping can refer to illegal round tripping and legal round tripping. Illegal round tripping would mean that if you give black money to someone and you ask him to have his relative or friend give you money outside India, so you get that money there and then you bring that back here. Like people sometimes do, they want official money here, they don't have that much, they've not paid their taxes, so they give money to a hawala dealer and have him give it to someone else who shows that he's making an investment into your company. So that's illegal round tripping. But there can also be a legal round tripping, because round tripping only means round tripping. It makes a round trip, the money goes there and it comes back to India. So per se there should be nothing wrong with just round tripping. There's something wrong with illegal round tripping, but not with round tripping. But the Reserve Bank seemed to indicate that round tripping was wrong. So in a particular case, I wrote to the Reserve Bank and I said that this is a person who invested in a company outside India. Let's say he invested $10,000. That company has now made money. It's earned much more. That company now feels that it can expand its activities in India by setting up a subsidiary in India. His 10,000 had gone there. Now that company's got 100,000. So can we not bring money back into India as an investment from that company here? Would that be treated as illegal round tripping? So the Reserve Bank of India wrote back saying, please come to us with specific facts and then we may consider this. So at least they've kept the door open. There is therefore a distinction between illegal round tripping and permissible round tripping, but one will have to go on the facts of each case and go and apply to the RBI wherever. So don't take anything for granted. I like to write to the RBI whenever there's any such grey area. And therefore that is another part of the scope of practice. And then of course there will be appearances before the Enforcement Directorate and appeals to the tribunal. And then there will be prosecutions which criminal lawyers will have to handle. Now, I've just given a little bit as an illustration of the FDI policy. This is what it looks like. The Department of Industrial Policy and Promotion, the DIPP, frames the policy. This is the consolidated FDI policy effective from 28th August 2017, and then this has been updated, as I told you, by a recent circular. Then the FDI policy on the next slide shows consolidated FDI policy circular of 2017, subject FDI, consolidated FDI policy. The policy is attached, the circular takes effect from this date, and then this is the index, the contents. So these are the different subjects that are covered in the FDI policy. The next one is the master direction relating to liberalized remittance scheme, that a resident Indian can remit out up to $250,000. For what can he use it? How does he have to report it, etc., etc. All that is written there. Then I've just given the first page just as an illustration to show you what it looks like. Then the next one is the master direction for foreign investment in India. So if a person wants to invest, then this is what he would look at. Now the Reserve Bank's head office is just around the corner here. It's in the new building, which is called the Central Office Building. Across the road is the main building, the original building, where also there's an office of the Foreign Exchange Department. In the FERA days, it used to be called the Exchange Control Department. Now it's called the Foreign Exchange Department. So they don't use the word control in this so much. And the tribunal, the head office of the Enforcement Directorate, that was of the Reserve Bank. The head office of the Enforcement Directorate is in Delhi. The regional office in Mumbai is at Ballard Estate in Kaiser-e-Hind building. The Tribunal for Foreign Exchange is in Delhi. And some important websites are the Reserve, rbi.org.in, then DIPP, and FinMin. So these are the ones on which you will get a lot of information about this. And of course, there are the books. So what is the future of FEMA? FEMA has been in existence for 78 years. At one point of time, as I told you, everything, the answer to everything was no. You just couldn't do anything at all. I remember the 1980s, once a person had come to me. They had a tea plantation. And they had been told by the Reserve Bank of India that you can produce, they used to process the tea, which grew on their plantations. They said you're allowed to process only, for example, 10 tons. Now, one year, they processed 12 tons. So the Reserve Bank sent them a notice saying, how did you do this? So I went to the Reserve Bank, I appeared, and I said that we've got your circular. You can see all these years we've been doing 10, 9.9, 9.8, 10, etc. But this year God was very generous to us. There was a wonderful monsoon. There was so much more tea. What would you have wanted us to do with the tea? Should we have burnt it or should we process it? So then the officer said fine, and he accepted it and he dropped the penalty proceedings. But they used to be so tightly controlled. There will be a point of time when everything is going to be allowed, like it was before 1939 or like it is in Dubai, Hong Kong, Singapore, America and England. But right now, those are not the times. There are lots of regulations. There are more and more every day. It's easier than it used to be in substantive terms, but much more complex in regulatory terms. So I'm sometimes reminded of a cartoon I saw in the Times of India once, that a cricketer, the batsman hit the ball, and then instead of taking a run, he sat down on the pitch, took out a pad from his pocket and a pen and started writing something. So the non-striker came up to him and said, what are you doing? Let's take a run. He said, no. First I have to fill out a form in triplicate. Thank you. Okay, thank you.
Question?
What are the definitions of FEMA in the cryptocurrencies?
You know, the Reserve Bank of India said at first that they were not recognizing them. They didn't say it was illegal. They said we are not recognizing it. This happened for several months, and then I think later the last was that the Finance Ministry said that they will treat it as illegal, but Reserve Bank has not come out with anything like that. So they are negative on it, but they haven't actually formally said that it's not legal. Although I think that under FEMA, anything other than Indian currency is to be treated as non-Indian currency, as foreign currency, whether it's currency in the form of cryptocurrency or currency from the moon or from Mars, it's all foreign currency. So it should be subject to the regulations under FEMA. And therefore, on the basis of the principles of FEMA, one should not be able to deal in that. But the Reserve Bank is not saying so as clearly as they might.
Anybody else?
If an individual goes out of India,
Yes.
and when coming back he has some currency balance with him and he keeps it as it is with him, is there any offense or?
See, if you bring back more than $5,000 or equivalent in cash, then you have to declare that in cash or traveler's checks. Then you have to declare that at the airport. The form used to be CDF, Currency Declaration Form. And then having declared that and got an acknowledgement for it, you bring it into the country and then you have to go and surrender it at a bank within 90 days. They have different regulations. In the past, the Reserve Bank used to be very particular. You are not allowed to hold any currency at home. In fact, I remember one person had a coin collection, and I wrote to the RBI, I also wanted to test the RBI on these things. So I wrote to the RBI saying that this person has got a coin collection of many different foreign coins. So the RBI didn't say, yes, it's approved. They said, give us details of all the coin collections. So I went back to them and I met them and I said, that's not possible. He has so many thousands of coins, so please give us the approval. So they gave the approval. But actually it was illegal to hold any foreign currency at all. Nowadays the Reserve Bank of India is more liberal. So if you have say $1,000 or $1,500 or so, they don't mind that. But if you have more than that, then they will say that it's a violation of FEMA.
Anybody else?
Thank you, sir, for this wonderful lecture. This is really very informative lecture. I would request Advocate Rahul Maskar, sir, to felicitate our today's guest, Advocate Anil Harish, with memento.
Thank you very much.
I would request our guest to write in our book. This is our tradition, sir.
Just sit and look at me.
I will call my colleague, Advocate Prathamesh Aire, to give vote of thanks.
First of all, I would like to thank our founder, Rahul sir, for giving me this opportunity to give vote of thanks. On behalf of Team Hammurabi Tablet, I would like to thank our today's speaker, Advocate Anil Harish sir, for enlightening us on today's topic, that is scope of practice in FEMA. I would like to extend my thanks to our cameraman Uday, Vidusha sir, for assisting to conducting this program particularly. Most importantly, I would like to thank you all for attending our lecture. So keep supporting and keep loving Hammurabi Tablet. Thanks a lot.
Now I'll just announce our next program. It is drafting skills for lawyers, and our guest is Solicitor Parimal Shroff. It will be a great pleasure to listen good tips from him. So please do come on the next lecture, which is on 18th of September. And as there are some people new, I'll once again say that Hammurabi has started a concept called I Enhance. And in I Enhance Advocate, 5 years and below advocate, we call them to become the speakers. That they have to pick up their own topic, select their topic, speak for, we have booked the venue for 2 hours. He may speak for 2 hours, he may speak for 45 minutes. So I Enhance is held on 4th Saturday. That is after this program, on next Saturday we will have I Enhance. Of course the venue is not this place. The venue for I Enhance is at Malad, Sage Plaza. It's a proper hall where we conduct it. So if possible, please do participate in that, because that is one activity where we are being trying that, you people sitting here should get more exposure. We get good sound knowledge from Anil sir and various other people, but we should also try to enhance ourselves. And that is the reason I have kept the name I Enhance. That you will study, you will talk, that you will only improve yourself. Nobody else is going to improve you. So that is that I Enhance program. So please do participate to that. Of course, on your registrations you will get the WhatsApp and the mail for that concerned thing. That from this 15th of August, we have started I Enhance Student. And now I want even students to take a legal topic and have the courage of speaking it for 45 minutes. And the intention behind that program is, I have been telling all the students that you please come and speak. Nobody is here to laugh at you. Everybody is here to encourage you. So let that speaking habit, let that confidence, let that boosting start in the student right from the day he is into the law school. That's law, that's I Enhance Student, that has been started initially right now in my office only in Kandivali. So if there are students over here, I would request them to participate in that. And once again, thank you for all, because today is our first Silver Jubilee program. It's the 25th program, and it could take place only because people like you, people before you, and people who will come after are encouraging more and more for us to conduct this program. So thank you very much once again. Thank you. So we will rise for the national anthem. गण अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उत्कल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।